I would like now to properly introduce everybody to the audience. Now we have 40 plus. I think we're expecting more, right, to come to the event today. So if we talk about the shipping and trade, maybe in a general observation, I usually say this, Melis, to my students. Whatever you have now, say it, your computer, your glasses, your watch, your phone, that might reach you through the ocean instead of other ways, right? So meaning that ocean, which is 70% of the Earth's surface, is actually very important. And that is now becomes very important why we talk about shipping and trade contracts. And now we have with us Melis Ozdel. Thank you very much once again for coming. Please, the time is yours.
It's great to be here, and today I'll be talking about one of the most strategically important maritime choke points in the world, the Strait of Hormuz. So for decades, this narrow passage has been the artery of global energy trade. As we all know, roughly 1/5 of the global oil supply, alongside significant LNG and fertilizer flows, routinely passes through this corridor. Although there are alternative infrastructure project options there in the region, such as pipelines, these are only partial substitutes. So past disruptions we have seen in the region have already triggered force majeure declarations and demonstrated the fragility of global energy supply chains. Yet, in recent periods of geopolitical tension, the strait is now raising deeper legal and commercial questions. So in addressing all these situations, I'll consider a number of interlinked legal issues with you. So first, I will be talking about how such situations are tackled in legal terms, with particular reference to two important tools that we have got, so two important contractual tools that we have got that we frequently see in shipping contracts, international sail contracts. So these are namely frustration and force majeure. And I shall also be discussing how and the high threshold that we see that is required for such contracts to be discharged in circumstances of war, disruption, or effective interference with maritime routes. And then I shall discuss how risk is allocated, particularly in voyage and time charter parties, with particular focus on the operation of standard form war risk clauses. So starting first with frustration and force majeure, I have checked the list of audience. I think many of the participants are from Indonesia. If that's correct, maybe you can just write in the chat box. I'm assuming that in your legal system, it's civil law. Is that right? Is it civil law or common law mainly? Thank you very much, Andy. So against all the background I've already given, so I'm now moving on to the operation of frustration and force majeure.
Right.
I have seen a reply here saying Indonesia is a common law jurisdiction. So proceeding on that, I'm assuming that you probably have got a similar doctrine of frustration that is applicable to contracts governed by English law. So what we therefore see when we have frustration in operation is its application is quite limited. And that is why in most commercial contracts, we do also see force majeure clauses. We don't have a doctrine of force majeure as such. In civil law jurisdiction, there is one, and that does apply because they have got their code, civil obligation code, that will require application of force majeure doctrine to any commercial contract, whereas we don't have such a mechanism in place. We have doctrine of frustration, which has got really narrow application. And in my speech, I will be talking about the threshold, particularly that threshold for contracts to be discharged, for contracts to be frustrated, what the courts want to see, obviously considering the current situation that we are in the Strait of Hormuz, the closure, the effective closure of that, whether it can can effectively frustrate contracts we have that are governed by English law. These doctrines are both force majeure and frustration doctrines that are quite important, significant, as I'm sure you know, because in defined circumstances, they excuse non-performance without giving rise to any liability for breaches. And I'm sure you all know frustration actually does require a supervening event, so beyond parties' control without their fault. And it really should ideally render performance impossible. So that's the gold standard, we would say. Or alternatively, rendering the performance of the contract radically. And the important thing there is radically different. So just because the performance has now become onerous, burdensome to parties is not sufficient to frustrate the contract. So looking at the situation that we're in, obviously the situation is burdensome economically to every party involved in the situation. But just because you're economically in a worse position is not a sufficient ground to say the contract is frustrated. So also, if we think about all the ships there, we don't have many ships that have actually been damaged. Most of them are just lying idle at the moment, waiting for the tension to ease. So that, in essence, tells us that we can't potentially speak of physical impossibility of contractual performance. We're probably steering more towards delays and whether these could radically alter contractual performance as the time passes by, whether the delay is significant, such as to frustrate the entire contractual advantage that the parties wanted to attain when they entered into contract. So that's what we're actually looking at right now. And that is why we see now many commercial parts going to happen and then decide what. Because if the contract is not frustrated and if you pretend that it did frustrate, then you obviously would put yourself in repudiatory breach, and that will mean you will be liable for substantial damages, and obviously no party would like to be in that kind of position. So it's quite important, therefore, to at least have some certainty as to whether frustration is actually a viable argument to make in the circumstances. We know from English case laws that delay may well frustrate contracts. So we have got some important cases like NEMA, where also, in that case, the House of Lords also recognized that in case of conflict, it's impossible to predict when the stability will return. And that uncertainty itself can make frustration sometimes difficult to establish, but obviously it is not impossible to establish frustration just because you have this uncertainty that we usually see in situations like this. But NEMA also itself acknowledges that you may well have some frustrating events that are not necessarily one-off, which is the situation we're in, affecting not just one party, two parties to a particular contract, but you may well have some events of a general character that may affect similar transactions between many persons engaged in the same kind of commercial activity, which is what we currently have. And in that case, the reference was made to things like closure of Suez Canal, the United States soybean meal embargo, the war between Iraq and Iran. So we have seen similar cases in the past, especially in that region as well. And we have also seen cases where the courts decided that the significant delays may well frustrate contracts. But the crucial thing obviously here is whether a contract is frustrated or not is context-specific inquiry. It's a fact-specific inquiry. There are no hard and fast answers. We don't have anything that we can actually apply to any type of contract at hand that are currently affected by the situation. So the context is therefore critical. Where you have got cargoes that are highly time sensitive, let's say you have got an LNG supply contract and the agreement there is to supply this into energy dependent markets let's say South Korea, etc., where you have a significant proportion of supply that may well depend on timely delivery. So the ability to wait and see may not be commercially realistic in those circumstances. And the delays that parties are currently encountering at this point in time, that can render the contractual performance radically different. So the crucial question is therefore the nature of the contract that is at hand, whether delivery, supply of something is time sensitive, the effect of the delay that will have on the contractual performance. So all those matters are important for the purpose of deciding whether the contract at hand can be frustrated or not. Another interesting aspect here is foreseeability, because we now need to think of two ways. This is an ongoing situation. Some contracts were concluded before the tension. People are still entering into contracts during the tension, right? And how are we going to place foreseeability into our analysis for contract frustration? It's an important factor. So if you look at any English case law, you will see some reference to foreseeability. Usually, while an unforeseen event will not necessarily lead to frustration of contract, in most cases it may. The event is unforeseeable. That could be something that could lead to and contribute to the contract being frustrated. But sometimes what you actually see is you have a foreseen event, and usually this is considered to exclude the operation of the doctrine. So if you have a foreseen event, the prima facie rule is the contract can't be frustrated, but still the courts do say, well, in exceptional cases, this can be excluded by evidence of contrary intention. So if you have an unforeseeable event, quite likely you may well be in a position to argue frustration. Obviously, other factors need to be considered as well, together with unforeseeability. If you have an event that is already foreseeable, it will be difficult for you to argue, establish frustration. It's not impossible. I mean, even in cases in NEMA, there was a frustration case. That was a frustration case. And the frustrating event was strike. And strikes are not unforeseeable events. They do happen. So what we therefore see is if the event is a foreseen event, the threshold for frustration gets a bit higher, but it's not impossible to argue frustration, establish it successfully, but it's not going to be an easy task. That is obviously what the courts do tell us. Now, to reinforce all this analysis on frustration, it's also important to refer to some important English cases, such as the Kyla. So there, the quite important thing that the court said was, frustration is no longer a rigid doctrine. It's not something that we are willing to categorically apply to situations where we see a supervening event. It is becoming more and more contractual and contextual. And Kyla is one of the key cases on that. The facts are not similar to what we're currently experiencing in the Strait of Hormuz, but it really does give us a very important reminder that if the contract itself makes some provisions for the event or contingency which has occurred, in those circumstances, the courts may well say the contract is not frustrated. Why? Because parties thought about that possibility, the event, the contingency, and they have put in place their contractual provision. And if that is the case, the court will say no frustration because you have got in hand your contract provisions about this risk allocation. So you have this contingency, you thought about it, you provided a provision in your contract, it has now happened. I'm not going to say the contract is frustrated because you have a provision in place to cover those situations. So this is very important. That is why we can now no longer say, and we shouldn't be saying, oh, we have a supervening event beyond the parties' control. Now the courts also want to see what you have put in your contract, what you have in place. Have you considered that contingency? Have you got any provision that can actually solve the issue about the risk allocation in relation to that particular contingency in question? So very, very important things that we actually see that, with the court decisions, clarifying these important elements that really help us understand how doctrine of frustration operates in modern times. Now, moving on to force majeure, as I have already said, we don't have a doctrine of force majeure. This is not something that is applied by law. It has got its contractual source, and you need to really have a specific, clear contractual mechanism in place for a force majeure event for a force majeure clause to operate. And it's really important if the parties want to excuse themselves from performance, it's really important for them to bring themselves neatly within the corners of the force majeure clause. We had a very recent, very interesting Supreme Court case, so Shipping, which actually told us something quite important, which is also very relevant to the situation that we're in. Usually we see in force majeure clauses provisions in relation to reasonable endeavors. So if you have got, let's say, some barriers, some harshness, some issues in relation to performance, you need to use your reasonable endeavors to try to comply with your obligation somehow in an alternative way. Now, the Supreme Court has said that you cannot obviously have a situation, let's say, where you have a party that, let's say, causes a force majeure event. They cannot actually ask the other party to use their reasonable endeavors and try to perform the contract with some non-contractual alternative methods. So what is a non-contractual alternative method for a contractual performance? What would be treated as a non-contractual performance? What will be considered as contractual performance? That will obviously depend on the contract at hand. But it's obviously quite an important reminder for us when we apply force majeure clauses. Now, looking at the situation we're in, looking at the Strait of Hormuz, so the legal threshold, what we see is it's obviously up to the parties to decide whether they should argue frustration or not. But as I have said and highlighted earlier, this is really a question of context and the contract that you have got. So you need to factor into a lot of things because in most cases you'll be arguing delay. And delay should be significant to frustrate the entire adventure. This is what you're trying to argue. It may not well be easy to argue. And you may also have got some issues in relation to your contract because you can have some provisions specifically covering such contingencies. That will also make it, in most cases, impossible for you to argue frustration. So force majeure clauses are fact specific, but we know that courts do not write the contract for parties. So doctrines of frustration, force majeure, they are not actually there. They're not mechanisms for rebalancing commercial bargains in response to geographical disruption. No, such as the one we have got. These are actually carefully constrained legal tools that operate within strict contractual boundaries. So in most cases, a lot will be decided and determined with reference to the contract clauses that parties do have. So the other issue that I want to discuss is the charter party risk structures. Because we increasingly see in charter parties, in void charters, in time charters, standard form raw risk clauses. So the two important ones are promulgated by BIMCO. So I'm assuming you do know. Yes, I mean, you can just write in the chat box. It will be nice to have some interaction. So if you have heard of it or not. So those are quite important ones. They are widely in use. So we have got two recent versions of those. So they are voiver, so void charters, and convert time for time to 2025. In the past, we had 2013 forms, so they're earlier versions. The recent versions bring a lot of clarification about wide range of things. So what should be understood by war, how the master judgment should be assessed, etc. The allocation of the excess costs and things like that. But if you look at the spirit and the essence and the main purpose of these clauses, they haven't changed. So the real meaning, the real functioning of these clauses have not changed, but more clarification has been brought with these new versions. It's still possible to see the old versions being used in charter parties. BIMCO has a very, very useful website, really explaining how the new versions operate, just to explain the clarifications put on there. So it might be an interesting and useful read for anyone who really needs to look into it for legal advice or other sorts of things. So conward time. So this is obviously one of the key clauses for time charters, giving the owners and masters the liberty to refuse charterers' orders. So giving broad liberty to master and owners. So the vessel, and it literally says the vessel is not obliged to proceed to or through any area where in the reasonable judgment of the master and owners, the vessel cargo or crew may be exposed to a war risk. So quite relevant to the situation that we're in. And this obviously applies, and that's quite important, whether or not the risk existed at the time of contracting or whether it arises later. So conward time clause is quite an important one and still has got this application. So let's say you have entered into a time charter party after the beginning of this tension, still your conward time clause will be applicable in theory, because it basically says that the right discretion to refuse to obey charterers' instructions, that right exists irrespective of the time of contracting. So whether after the war or before the war. So which is good news. One of the crucial things is how this judgment is actually applied in practice. So what is the master or the owner should look into? So how they're expected to exercise their judgment. So what should be the level of the risk that they should see for the purpose of being able to say we are refusing to comply with the order. We don't have a recent case that actually deals with reference to the newest version of the conward time clause. But we do have an English decision, which is the Triton law. So although this case was concerned the conward time 1993 wording, the previous wording, it can still be applied to the new wording because, as I said, there are no dramatic, massive changes between the two. And it really clearly says if there is a bare possibility of risk, it is not sufficient for the master or the owner to refuse to comply with the charter's orders. The assessment of risk, the court says, must really be grounded in evidence. We don't expect a very high threshold here, like 50-50 probability. But really, you need to have a situation where the risk actually can be shown and substantiated with evidence. So it shouldn't just be a bare possibility. So you're basically looking at between those two things, two extremes. And so speculations, probabilities, they're not going to be sufficient. You really require a genuine evidence-based assessment of a real or somewhat credible risk to be able to refuse to comply with the charter's orders. Another important thing, so there are always ifs and buts here. Another recent Supreme Court case, the Polar, which is a very, very useful case, particularly when dealing with situations like this. It says a number of things, but the most important thing here is, yes, you have your conward time. You may well say it's great. And it clearly says, well, it doesn't matter whether the risk exists before or after. Fantastic. But this Supreme Court decision clearly says that there's got to be a qualitative increase in the risk. If you have already entered into a contract, a time charter, at the time you, let's say, have got this warlike situation, in the Gulf, in the Straits, and if you're just relying on your conward time, just beware, because for you now to be able to refuse the charter's orders, you need to show that there is a qualitative increase in the risk, because at the time you entered the contract, both parties were aware of the risk. So that's obviously the crucial thing. So now to be able to refuse to comply with charter's orders, you need to show not just the risk, which already existed, but increase of that risk that the parties were already aware of. So that's very, very important. And there also the court again looked into the contractual context and said, well, in relation to the situation in relation to the Gulf of Aden, you have got a contractual provision covering that contingency, about the war risk insurance, and that led the court to think maybe you shouldn't have the right now to just make a fuss about it because you have got your contractual provision in place, so that should be given effect to. So convert time clauses, they will be given effect to, but the crucial thing here is they will not be interpreted in isolation from the remainder of the charter party. So you can't just rely on your convert time clause and say, I always will have this unrestricted discretion to refuse to comply with charter's orders. The court will not read it, the convert time clause, in isolation from the remainder of the time charter provisions. So what all these contracts, what all these cases do tell us that courts will always look into not just one thing, but the contract as a whole. And the crucial thing always for the court is to find out, ascertain objectively the party's intention about risk allocation. And that is a crucial thing. And we can see this repeated pattern in these judgments. So what the parties intended about risk allocation is the crucial matter for the courts. And that's what obviously they're trying to ascertain with all these exercises with contract interpretation. Now, I only have 3 minutes, so I shall be very, very quick now. Okay, so what if you don't have convert time in a time charter situation? Does that mean that the owner can now and should go wherever the charter wants the vessel to go, including all these dangerous zones that we have got, let's say the Strait of Hormuz? Well, each situation should be assessed on the facts, but the crucial thing is just because you don't have convert time form doesn't mean that you now have got no discretion, no power to say no to a charterer. Because we know from English cases, there is this traditional dividing line between employment orders and navigational orders. So if you think that the charter's order is going to put the vessel at risk, you have the discretion to say, no, I'm not going. But the crucial thing is if you have a provision in place, that obviously puts you in peace because you'll then be in a position to effectively rely on it. Because what obviously may well happen in a situation is if you don't have a convert time form, there could be some arguments about assumption of risk, whether the parties actually knew this, whether the owner actually assumed the risk of going there at the time the parties entered the contract. So it's always good to have convert time clause in place. But just because it is not in your time charter party doesn't necessarily mean that you have now no right to refuse to come. If the charter's order is likely to pose risk to the vessel, likely to put the vessel at risk, you have the obligation as an owner, apparently, to say no to the charterer. Because if you don't say that, and if you just let the vessel go to somewhere that is, apparently dangerous, putting the vessel in immediate danger, that will break the chain of causation, and you will then no longer be in a position to get any indemnity from the charterers in the first place. So those are obviously the important things. Void charter scenario. So we also have a war clause, BIAMC war clause for void charter parties. It obviously comes up. So if for example, risk is identified prior to loading, the owner may well cancel the voyage if no alternative port is nominated. So if you go through that, you will also see quite useful set of rules there in place. Obviously, that has to be part of your contract. It's not possible for these things to be applicable to your contract if you haven't incorporated them in the first place. So central to all these things, the master's assessment, risk assessment, must be made in good faith. It has to be objectively reasonable. And you're not looking at theoretical risk here, but real likelihood or serious possibility of exposure to war risk, which does obviously exist in the situation. So it should therefore be possible in most cases for masters and owners to refuse to comply with charterers' orders. And one last thing, because I don't have time now, so just to wrap it up. So what if you have got delays? Well, obviously, you have got now many vessels that are delayed, they're lying idle. What's going to happen if you are in the course of your time charter? Well, whether the vessel is going to be treated as off hire. The quick answer to that is if you just have got your basic NYPE, the answer is no. Much will obviously turn on your off hire clause, how that is worded. Just because you have whatsoever may not also necessarily save you. Again, you need to look at your fire clause in its entirety to make an informed decision on that. So that's what I'm going to say. And if you are in a time void charter, obviously the main regime is lay time in demurrage. If lay time has already started, and if your vessel is waiting idle, well, obviously demurrage will run against against the void charterer. How far it can go, as far as it can frustrate the contract, as we can say, but obviously that is another risk for parties. So all these things that we see are actually all about risk allocation, and there are various aspects to these things, as you can see. The significant delay that's happening in this trade is obviously causing a lot of legal problems to parties, and all really boils down to risk allocation. The doctrines, even those I mentioned, they clearly say that no court, no arbitrator is going to rebalance parties' commercial bargain, and much of those issues will have to be resolved with reference to the contracts that the parties have. So thank you so much for your time. So that's it from me.
Thank you very much for your explanation. I think it is very interesting to observe. But allow me a little bit to do a backward here, like a small introduction, because I'm supposed to do that, but I don't want to uh, put you on hold earlier. So just for information for the audience, that Dr. Melis Ozdel is actually the head of maritime law at UCL London. Thank you very much once again. And you have, I know you have a extensive experience because before you're also the director, right, of the UCL Centre for Commercial Law, and you specialize in international trade law, carriage of goods by sea, international commercial arbitration, and also conflict of laws and jurisdiction. So very, very good expertise over there. You talk quite extensively about this. I really appreciate. If I may, a little bit, summarizing this. So I understand that but you mentioned earlier, although newer BIMCO war risk clauses provide clearer guidance, basically, but the core purpose remain unchanged, right? That's how we understand. And also, you mentioned about the possibility to apply doctrine of frustration and so on and so forth. I think we will come back to talk about this. Now, I would like.